Coming to you from the Forge of Freedom studio in the heart of America. A podcast dedicated to preserving freedom and inspiring personal success. Freedom is born and lives through you, the individual, and it dies in the shadows of tyranny. Motivating our listeners to become well-rounded, freedom-minded people with the body of an athlete, the mind of a stoic, and the spirit of a warrior. The tree of liberty lives on through you, the Forge of Freedom. And now here's your host, Alex Ooley.
Hello everyone, and welcome to another edition of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 46 of the Forge of Freedom. Today I have a special guest to discuss his book, Stephen Halbrook, and the book is called America's Rifle, The Case for the AR-15. Welcome to the show, Stephen.
Good to see you, Alex, and I'm going to just show the book. I'm going to hold it up right there. It's in both paperback and hardback, and you told me it's in Kindle too.
It is. I have a copy on Kindle. Is there any place in particular I got mine off of Amazon, where I know lots of folks get their books, but do you have any other sources where, in particular, where it's good for them to get the book?
Not really, just wherever you please. Some people don't like Amazon, and I'm sure Barnes & Noble has it, and some of the others, whatever your preference.
Yeah. Well, I was in Books A Million the other day looking for a copy and couldn't get one. They didn't have it. They had to order it for me, so I just broke down and got it from Amazon. But anyhow, for those who don't know Mr. Halbrook, Stephen Halbrook is a senior fellow at the Independent Institute and one of the most, if not the most, prolific author and attorney on the right to keep and bear arms. He has written extensively about the original meaning of the Second Amendment and the 14th Amendment as applied to the Second Amendment right to keep and bear arms. He has taught legal and political philosophy at the university level and received his legal degree, his law degree, from the Georgetown University Law Center, and his Ph.D. in social philosophy from Florida State University. Stephen has also argued and won 3 cases before the United States Supreme Court. The Printz case, the Thompson Center Arms Company case, and the Castillo case. And to varying degrees, Stephen has had a hand in other major cases before the Supreme Court, including Heller, McDonald, and Bruen. In fact, Mr. Halbrook's works have been relied on by Justices Antonin Scalia in the Heller decision and Samuel Alito in the McDonald decision. There's certainly much more to say about Stephen's accomplishments, but I think it would be nearly impossible to find someone who rivals Stephen's impact on the preservation of the right to keep and bear arms. So with that said, once again, welcome, Stephen, to the show, and let's get into the book, if that's okay with you.
Pleased to be on the show, Alex. Thank you.
Yep. So to start with, I guess, why this book about the AR-15, America's Rifle? What inspired you to write this book?
Well, we've been through different stages in the scholarship. If you turn the clock back to the 70s and 80s, we had many academic people and court decisions saying that the Second Amendment doesn't really mean anything. It's a collective militia right. It says that the right of the people to keep and bear arms shall not be infringed, but it doesn't really mean the people. It means the National Guard or the states or whatever they want it to mean. It means anything you want it to mean. So I started doing scholarship among other scholars, Don Cates and David Kopel and David Hardy, many others. The first thing we had to do was to demonstrate that it's an individual right. And so one of my earlier books is called The Founder's Second Amendment, and the Heller case was pending before the Supreme Court when that book came out. And of course Heller held that indeed it's an individual right. And then the next issue was going to be, does it apply to the states through the 14th Amendment? I had litigated California's ban that was the very first rifle ban in U.S. history, enacted in 1989. And the court held that the Second Amendment does not apply to the states, and the 14th Amendment does not incorporate any right to bear arms. And so I wrote a book to counter that, and it's called Securing Civil Rights, Freedom, the 14th Amendment, and the Right to Bear Arms. And that book was written for that very topic, and indeed it was cited in Heller and then in McDonald. And so then we go to the next level, the right to bear. Heller said the right to keep arms in the home is protected. But then we get to the next level, which is there really a right to bear arms outside the home? And so my next book, which came out, it's been 2 or 3 years ago now, the right to bear arms, a constitutional right of the people or a privilege of the ruling class. And so then we have the New York State Rifle and Pistol Association versus Bruin case, the very favorable decision. And then I figured that one of the next issues the Supreme Court's probably going to look at is the bans on commonly possessed rifles and magazines that the anti-gun people like to call assault weapons. And so that's the reason for this book. I've worked on that issue in scholarship and in litigation for decades now, and I'm hoping the book is timely. When Bruin was decided, the Supreme Court sent back to lower courts cases involving the Maryland so-called assault weapon ban and magazine bans in Jersey and in California. So there again, I think that tells you something. Those cases are going to perk back up to the Supremes, and that's where I hope the book will be helpful to people who are going to be covering that topic.
Well, hopefully we can have an interview like this in a few years, and you can say that this book was cited by the Supreme Court in an assault weapons case. Which brings me to my next point, the term assault weapon. Can you talk a little bit about that? I know you get into that in the book. Where does that come from? Obviously, AR-15s are often painted as assault weapons by the media, but that's really just a made-up term.
If you go back to the origins, it's the term means what it says, and that's why you can find legal cases that say the broom was the assault weapon used by the prisoner when he assaulted the prison guard, or a hammer was the assault weapon used by the person who committed the assault. I mean, literally, that's what it means, and you'll find court decisions where that's the use. But it used to be handguns were bad, rifles were good. And all the way up until the Heller decision, the anti-gun people were saying that because they wanted to ban handguns mostly. After Heller was decided, which said handguns were protected, it then became handguns are good, but rifles are bad, semi-automatic rifles. And so if you go back, though, all the way back to about 1989, the Violence Policy Center, I believe, was the organization that basically originated that term as a propaganda term to try to make it sound like ordinary rifles that so many people, millions of people nationwide have, to make it look like there's some kind of fierce, dangerous, to be afraid of kinds of rifles. So that's where that term really comes from. And the irony here is that the jurisdictions that have enacted bans don't know what they're talking about, but they probably don't care either because they have completely contradictory definitions. If you go to Illinois, for example, a rifle with a protruding pistol grip is an assault weapon, a semi-automatic rifle with a protruding pistol grip. So by definition, a rifle has a shoulder stock. So basically that definition is a long gun with a shoulder stock and a pistol grip is banned. But if you go to Cook County, their ban says that an assault weapon is a semi-auto rifle with a pistol grip without a stock. And then if you go to the Maryland ban, neither one of those makes it an assault weapon. So you can have it a pistol grip and a shoulder stock, or one of the above, not the other, and it's not an assault weapon. So it just shows you how arbitrary these classifications are. But what's what's amazing, I'm waiting for somebody to explain why a rifle loses Second Amendment protection because it's got a certain way of holding it, like a pistol grip. Mm-hmm. So, in California,
or a pistol stabilizing brace.
There you go. That's another arbitrary, made-up thing.
Right.
But in California, you can't have a pistol grip where you can grip it with your thumb around the grip and your fingers on the other side, like you would normally grip a pistol, for example. You can't have that on a rifle. But if you have a protrusion that gets in the way so that you can't wrap your thumb around it, I call it the hitchhiking position. If you hold it like this, then it's legal. And so, I mean, please, you're telling me one of those has Second Amendment protection, but the other one doesn't.
Yeah, and I think you're right to point out how arbitrary some of these line drawing things are that legislatures engage in, to some degree, it seems like it's intentional that they want this sort of amorphous definition of what it means to be an assault weapon that's banned. It just sort of changes depending on, like you said, just very small details about how you hold the firearm, for instance, and it just seems completely arbitrary. One thing I'd like to mention, I mean, in your book, you obviously go through a lot of the history, drawing out sort of the right to keep and bear arms and where it comes from. One thing I appreciate about your book is it's a history book, but I think your background in philosophy may have some to do with this. It's also somewhat of a political philosophy book because you don't just tell the history, you tell the why behind it in lots of circumstances. And you mind to say just a little bit about that, how your background in philosophy has informed your views about the Second Amendment?
Well, if you look at the influences on our founding fathers, Thomas Jefferson wrote that the Declaration of Independence was based on the writings of Aristotle, Cicero, John Locke, and Algernon Sidney. And if you get into those works, you understand. The Declaration of Independence made it very concise, but those works give you the background to understand that civilization has a continuing battle between freedom and slavery. Aristotle talked about the polity as being the ideal state, and the opposite of that is a democracy, which is the type of mob rule. And when you get into John Locke, you've got the idea that there's a state of nature, there's a fictitious social contract in which we all are members of, and you agree that there can be a government and you go by rules and laws, but you have a right to self-defense that you never forfeit, and you would never disarm yourself when the state itself is armed. And so you have the idea, and like in the Declaration of Independence, we have all men are created equal, they're entitled to life, liberty, pursuit of happiness, and if you have a government that tries to become tyrannical, then you overthrow it, and that's what America was founded on. And if you look specifically at the right to bear arms, one curious thing, I don't really like monarchy. I learned that from Thomas Paine. We don't like monarchies. But if you look at medieval England, the monarchs imposed a duty to bear arms on the populace. And with all the tyrannical things that went on in those days, you still had arms in the hands of the people. The English longbow was one of the most powerful weapons in history at that time. And this idea that you're keeping the longbow in your home leads to the idea that it's my property, it's my arms, I have a right to this. And if you go to the English Declaration of Rights of 1689, you have an explicit declaration in regard to the right of Protestants to have arms for their defense and security. And of course, when James Madison wrote the Second Amendment, he crossed out Protestants and put in the people.
Mm-hmm.
But that I think that background, I think you're right. It did give me the ability not to look at all of this just legalistically in terms of court decisions and what was the overall philosophy of our founders. Why do we have a Second Amendment? And I think the key is in that background.
Yeah, and I think you do a great job in the book of drawing out that background and not just the factual history, but the why behind it and the philosophical underpinnings of the right to sort of self-ownership and to self-preservation, and the Second Amendment as a recognition of that. So I think that you do a great job of that. One thing that you've already mentioned a couple of times in our conversation is arms that are ordinarily or commonly possessed. Can you talk about that a little bit, this sort of notion of this common use and the common use doctrine that has developed since Heller, and why the AR-15 is certainly included within that definition?
Well, Justice Scalia wrote in the Heller decision that the kinds of arms that are in common use by law-abiding people for lawful purposes are protected by the Second Amendment, and alternatively, arms that are typically possessed by law-abiding people are protected. And Scalia didn't actually make that up. If you can go back to some of the 19th and early 20th century cases and see other judges giving that a similar formulation. And the idea is that we'll go back to St. George Tucker, who wrote the first commentaries on the Constitution in 1803. He said that the Bill of Rights is written for the people to understand their rights. It's not written for the government to decide which rights we're going to have. And so the idea that the arms that are in common use are protected reflects that it's the people's decision. In the Heller case itself, the District of Columbia banned handguns. But it's a matter of fact that handguns are commonly used and possessed by law-abiding people for personal protection, as well as target shooting, recreation, and other things as well. So that's where that test gets us. And we know the most popular semi-automatic rifle today is the AR-15 type. It comes in many variations and different calibers. But there are many, many millions of Americans who possess this rifle. And it's mostly used for target shooting and hunting. If you look at the actual uses in which shots are discharged, it's possessed for self-defense. Luckily, most guns never get used for self-defense. As a matter of fact, I mean, how many of us ever have discharged a firearm at a person, and none of us want to ever do that. But you keep them for that reason, and you have a right to do it. So the reason I called the book America's Rifle, it's the rifle that's most widely chosen by the American people as the perfect embodiment of an arm that's protected by the Second Amendment.
Yeah, and in fact, I think you draw out some numbers. I don't have the numbers at my fingertips here, but there are, I think, some 40 million or more in circulation in hands of lawful owners, and that there are more in circulation than there are F-150s on the road, right? That the most popular pickup truck in America, and
right.
There are fewer of those F-150s than there are AR-15s. Yeah. So I think, and we certainly, one thing I'd like to mention the Caetano decision, because Caetano didn't involve firearms. It involved a different type of arm, but the court in that case said that there were, I think, a few 100,000 of these stun guns, maybe 200,000 of these stun guns in circulation, but nevertheless determined that they were arms that were in common use. Is that basically correct?
Yeah, that case involved this Commonwealth of Massachusetts banned stun guns, and Ms. Gaetano was a victim of domestic abuse. Her boyfriend beat her up different times. There was a restraining order; it didn't do much good. So she carried a stun gun, and she was caught with it in a parking lot of a grocery store by the police, and so they convict her. And it goes to the Supreme Court. It was a very little-known case. Nobody thought the court was going to do anything with that. And Justice Scalia had died, so it was kind of 4-4 in terms of pro- and anti-Second Amendment justices at that time. And lo and behold, on its own, without oral argument, the court rendered an opinion 8-0, basically saying that Heller had adopted the common use test. The High Court of Massachusetts had misconstrued that test. They sent it back for further reconsideration. Justice Alito wrote a concurring opinion, basically setting forth a lot of the facts in the case. And what was incredible, Massachusetts banned these stun guns. They're not lethal. And it's like they don't want anybody to have an ability to defend themselves. And here you have, they prosecute this abused woman for that. I mean, what kind of prosecutors do they have who would do that? I mean, you let a lot of things go if it doesn't merit prosecution. And so the case went back to the Massachusetts Supreme Court. And so then they dropped the charge because they didn't want that court to have to render a decision consistent with the Heller decision, but they couldn't avoid it because I think then there was maybe a declaratory judgment, a civil action that was brought where the Massachusetts courts had to recognize that stun guns are protected. I mean, we have a right to keep and bear arms. Arms comes in many forms. A stun gun is a modern, not lethal weapon, but there's also knives and clubs and all the traditional arms that people had before firearms were even invented.
Yeah, and it's all those arms that are in common use and or are typically possessed for lawful purposes, right? And that includes, as you say, lots of different types of arms.
Yes.
Including certainly the AR-15, at least in our estimation, because where there are only a few 100,000 stun guns and they're in common use, and there are multiple millions of AR-15s certainly in common use and typically used for lawful purposes.
That's right.
Yeah. One thing I'd like your thoughts on, and I think you allude to this a little bit in your book, is that the way that criminals use certain items or exercise certain rights should not dictate how others' rights are protected. So, for instance, if somebody uses their First Amendment right to speak freely in a way that's harmful to others, that shouldn't dictate how my rights to speak freely are dictated. Or just because there are lots of people who may be apprehended if we didn't have the right to be free from unreasonable search or seizure, just because it may be beneficial to society in some way to catch more crimes, doesn't mean that I'm going to lose my right to be free from unreasonable search and seizure. But that doesn't seem to be the case with respect to the right to keep and bear arms. Routinely, the way that criminals use firearms is used against the law-abiding citizen as a justification for taking away our rights. Can you talk about that a little bit?
Right. We would never let criminal misuse of a Bill of Rights guarantee, a constitutional right, dictate that law-abiding people, the ones who these rights should be exercised by, cannot exercise those rights. And so, using your First Amendment analogy, some people commit libel and slander. They defame others, and that's actionable. It's usually a civil matter, not a criminal matter. But there are criminal modes of speech. During a wartime, there may be subversive types of speech or different kinds of speech that might be a crime, but we don't shut everybody up because of that. And we have, the fact is, in this country, in terms of criminal misuse of firearms, handguns would be the leading type of firearm that's misused by criminals. And yet Heller held that doesn't mean that law-abiding citizens have no right to have them. If you want to look at the data, just go to Chicago, on the streets of Chicago. You've got dozens of people being shot every week. Murders so numerous. It's so sad. We also have sometimes criminals choose rifles to shoot people in mass shootings. But if you look at the data per year, you'll have, I guess it's 5-digit numbers of people who were killed by handguns or with handguns every year, and it's in maybe there'd be 200 killed with rifles, and I want to avoid saying killed by a gun, because the guns don't kill anybody. Criminals do that. And we have a problem in society with the people who run amok and just shoot people at random. These cases are so newsworthy and so out of the ordinary, so fantastic, that they get so much coverage, but they're really very small compared to your everyday murders where bad guys use guns. So what is it about our society that we're having these? Well, you can go back to the country's founding, and there's been mass killings. Almost the entire population of Jamestown was wiped out in about, 1624, something like that, by hostile Indians, and it was several hundred people. So we've had race riots in this country, Tulsa, in the early 20th century, where you have a lot of killings, and now we have the phenomenon of these school shootings and whatnot. And what's become of our society? We have so much animosity. We have the electronics have taken over young people. I don't pretend to know the causes of all of this. I don't think anybody does. But try to blame metal arms for this is just impossible. I mean, if one type of gun wasn't used, another type of gun would be used. Yeah. So we have a problem. We need to do something about it, but not by infringing on constitutional rights. You allude quite often, or a few times anyway, to prohibition in your book, and how a lot of alcohol was imported from Canada, and I think that and I guess part of the point I'm trying to make here is that where criminals want to get their hands on a product, whether that's alcohol or drugs or arms that are outlawed, they will, and they'll use them for nefarious purposes. And all that these arms prohibitions do is create a black market and disarm the law-abiding citizen. Is that a fair statement? That certainly is, and you can go back in history to some of the classical political philosophers. Bisiaria, the Italian penal reform advocate, said that we don't ban water because people drown in it, we don't ban fire because people get burned with it, and to disarm the law-abiding people only makes things better for those who commit the assaults and worse for the victims. And that goes back to the mid-1700s, that work, and that was one of the favorite authors of Thomas Jefferson, John Adams, and some of our other founders. And it's as true today as it ever was true.
Yeah. Well, we're coming up on time here. I know you've got other things yet to do today, and I know you're a busy man. But one thing I'd like to bring up is the Supreme Court. Obviously, we're hoping that the Supreme Court eventually takes up a case involving the AR-15 or other commonly used arms. But at this point, the only case they've accepted for review is the Rahimi case. What are your thoughts on that? I know there's a lot of concern about that case having been accepted, but there's also significant upside potentially. What are your thoughts on that case having been accepted by the Supreme Court?
Well, there's a federal ban on possession of a gun by a person against whom there's a domestic violence restraining order. And there's two prongs to that finding being made. One, if a court decides that you've actually threatened violence, they can enter the restraining order, or if there's just a finding that that a person has agreed not to commit violence against a domestic partner. And the problem is, in that second category, people agree to that all the time. Why wouldn't you? In a typical divorce, I got no problem saying I'm not going to, commit any acts of violence or assault against my ex. Why would I want to do that? But if that order is entered against you, then it's a felony for you to possess a firearm. And so Mr. Rahimi had an order against him. There was no hearing, and he just volunteered for it. That way he didn't have to pay the DA's attorney fees. But he's also a kind of guy who has a criminal history. He's been arrested for a number of other offenses, assaulting people, shooting guns off in public, dealing drugs, whatever. And he's incarcerated right now. So the federal law that he's charged with really is kind of inconsequential. And in fact, we know that there are...
as it pertains to him, right? I mean, inconsequential.
Well,
yes.
Yeah. There's only a few hundred of these prosecutions every year. By contrast, there's tens of thousands of prosecutions against felons in possession of firearms. But the state of Texas is going to take good care of him. I mean, these other things he's charged with are serious crimes. Mm-hmm. And yet, Merrick Garland, the Attorney General, was just, couldn't wait to get that case to the Supreme Court, because the U.S. Court of Appeals for the Fifth Circuit said that our founders never anticipated that a law like that could result in disarming someone. A law saying that if there's a domestic restraining order against you, there's nothing in our history until that law was passed in the 90s that was equivalent to that. And mind you, at the state level, though, the restraining order itself tells Mr. Rahimi that he cannot possess guns. So it's kind of a tempest in a teapot, but it could well lead to a decision by the Supreme Court that a lot of people won't like, or that might curtail Second Amendment rights.
Right. Yeah. Well, I'd like, just in closing, give you a few moments here just to, I guess, kind of give your elevator pitch for the book, and then also what is the case for the AR-15 as America's rifle.
Well, I'll just do something really quick and chronological. Our right to bear arms was originated in part by the duty to bear arms that was imposed by the monarchs in England. We go up to the English Glorious Revolution, and this right gets solidified in the Declaration of Rights. And then if we continue that journey to America, the colonists found out very quickly they needed to have arms, and bearing arms was mandated when you went to church or when you went to other places because of the massacres that some of the hostile tribes were committing. And we know the British tried to disarm us, and our reaction was, we don't lie still for that. We have our rights, our traditional rights as Englishmen, and so we have the idea. The Second Amendment gets adopted in part because of the experiences with the British disarming the colonists. And if we go on up through the 19th and earlier 20th centuries, we have the fact that minority groups use arms to protect themselves. For example, African Americans frequently would use arms to prevent lynchings or race riots that were directed against them. But we also have the fact that Congress passes a lot of bad laws, but with very few exceptions, they've never thought that they could actually ban mere possession of guns. They did that with their so-called assault weapon ban, but it only lasted 10 years and it expired. Everybody knew it did no good. And then other things are going on. The fact that part of our military preparedness has to do with people being familiar with use of rifles, for example. So we have the civilian marksmanship program instituted in the 1920s, which is still in existence now, and which promotes rifle marksmanship with the M1 Garand, the M1A AR-15 type weapons also, and that if you're a young man, you might go into the service, and this became very important leading up to World War II. That program, along with the NRA, trained unlimited numbers of young men who were going to be sent abroad, and their rifle was their best friend. That could either protect them, or if they don't know how to use it, their chances of coming back were greatly decreased. So there's nothing wrong with this rifle. It's a very fine rifle that's desired by many Americans, and the idea that it should be banned is something that the courts need to get on the ball and reject. We've got a lot of litigation going on right now on this very issue. It started out there were only 6 states that have bans, and a week after the New York case came down, the governor of Delaware signed a ban for that state. It's like he didn't even read the opinion. And then after that, we now have Illinois following suit. So we'll see where this goes. But it's still a very small minority of states. I think it's 8 and maybe 9 that have some kind of ban. But the other 42 don't. The other 42 free states don't have those bans, and they also respect the right to bear arms, to carry handguns. So we'll just see what the courts do next.
Yeah. Well, I think it's an excellent book. I enjoyed it very much. The history, the why behind the history, not only the AR-15, but the history behind the right to keep and bear arms. And I think certainly that you make a very good case, not only for the right to keep and bear arms, but for the AR-15 as America's rifle. And one other thing too, I think you mentioned that some of the gun control, early gun control around newly freed slaves. That's a lot of the history that the gun control groups today are citing to support the upholding their gun control schemes. And it's a lot of people don't realize that most of the early gun control was to prevent newly freed slaves from having arms. So I think that history in the book is really interesting as well. And finally, I'd like to say too that you mentioned the book is available on Amazon and on Kindle. You also have some other books I'd encourage folks to check out as well. Gun Control in the Third Reich is one that I've read. I haven't read all of your books, but I know that one was a good one, and I read it. Are there any other books you'd like to plug before we close out here?
Well, look at my website at stephenhalbrook.com. I have a book on the disarming of France by Nazi Germany. My first major book was called That Every Man Be Armed, The Evolution of a Constitutional Right, and that starts with Aristotle and Plato and the ancient philosophers and brings it all the way up to today, that topic historically. So just look at the website. I've got a lot of articles that are posted on it as well. I contribute regularly to what's called the Volek Conspiracy, which is a blog that has some really first-rate legal minds contributing to it. So
yeah, I'll link to that. I'll link to your website, and the Volek Conspiracy is on Reason Magazine's website, right?
Yes.
So I'll link to that as well. Anything else you'd like to say before we close off here, Stephen?
No, Alex, I just appreciate you having me on your podcast here, and I've seen your website, and you've got a lot of really great people. Masad Ayub, for example, was one of the recent ones, I think, and so I just wish you good luck and keep up the good work.
Well, thank you, Stephen, and thank you for joining the podcast. I know our listeners will certainly enjoy the podcast, but hopefully they'll buy your book and enjoy your book as well. So thanks again.
Okay, take care.
All right. Take care, everyone, and I hope you enjoyed the show. Don't forget to like and subscribe to help us spread the message of freedom. Until next time, remember, you are the Forge of Freedom.
Thanks for listening to this episode of Forge of Freedom. Be sure to subscribe wherever you heard this podcast so you never miss a future episode. For more information or to connect with Alex, you can go to forgeoffreedom.com or follow him on Twitter @ForgeOfFreedom. Until next time, remember, you are the Forge of Freedom.